I'm going to introduce our two speakers and then I'm going to hand it off to them. So first, I'm going to introduce Emmanuel Jenkins. So Emmanuel Jenkins, the driving force behind the transformative nonprofit We Stand for Something, is the living embodiment of empowerment. His organization serves as a radiant beacon of support for individuals with disabilities and their families, spreading positivity and instilling hope in every endeavor. In the dynamic landscape of Delaware, Emmanuel stands out as the dedicated community relations officer for the Delaware Developmental Disabilities Council. His commitment transcends the ordinary. Emmanuel is not just an employee, but a true catalyst for change. He holds influential roles as the chair of the Delaware Employment First Oversight Commission and vice chair of the Delaware Developmental Disability Services Advisory Committee, steering the course towards progress. As alumnus of the Partners in Policymaking program since 2014, Emmanuel's journey is defined by an unwavering dedication to advocacy. A recent addition to the Advisory Committee for the Self-Advocacy Resource and Technical Assistance Center, and the chair of the National Association of Councils on Developmental Disabilities Self-Advocacy Committee. He tirelessly propels the cause forward. Emmanuel also serves on the board for the National Association of Councils on Developmental Disabilities and chairs the NACDD Communications Work Group, amplifying his impact. Emmanuel's influence extends to academia, where he proudly serves as a distinguished LEND faculty member for the University of Delaware, self-advocacy discipline following his completion of the LEND cohort. As a devoted family man, married since 2009, Emmanuel is not just a father to a vibrant 18-year-old. He embodies the living testament to the transformative power of motivation. With over 2 decades of experience as a motivational speaker, Emmanuel's words resonate with wisdom and inspiration. Envisioning the future, he passionately dreams of securing a seat in Congress, where his tireless advocacy can elevate to new heights. In the intricate tapestry of Emmanuel Jenkins' life, every thread weaves a story of resilience, determination, and the unshakable belief that we can all stand for something greater. That is a really awesome bio. So that's Emmanuel. And then I will now introduce our other speaker, Marissa. So Marissa L. Band Esquire is the project director of the Disabilities Law Program, DLP, of the Community Legal Aid Society, Inc., also known as CLASSY. The DLP serves as Delaware's protection and advocacy system. Marissa has been a practicing attorney at CLASSY since 2008, where she has worked in both CLASSY's medical legal partnership and CLASSY's disability law program. In these roles, Marissa has assisted children and adults in a variety of special education, disability rights, public benefits, immigration, and poverty law matters. Marissa has also furthered the rights of Delawareans with disabilities via service on numerous councils, committees, and task forces. Marissa has a BA from the University of Michigan, Ann Arbor. She obtained her master's in public affairs and politics from Rutgers University Edward J. Bluestein School of Planning and Public Policy, and her Juris Doctorate, magna cum laude, from the Rutgers University of Law. So please welcome both speakers. As you can tell from their bios, they are exceptional, and I'm going to hand it off to them to get started with this webinar. Thank you all so much.
Thank you. And wow, Emmanuel, I need to step up my bio. That was beautiful. Today we're going to be speaking about accessibility in services for survivors of crimes. Because I am an attorney, I of course had to add a disclaimer to this presentation because lawyers like to add disclaimers to everything they do. This presentation is not legal advice. It's general information and is meant to be informative. But every person's situation, every business situation is unique. And if you have specific concerns, well, we do have a Q&A at the end. If you have specific concerns that you need legal advice about, that would be something that you would have to consult with an attorney about specifically. All right, Emmanuel, you want to introduce the DDC?
Thank you so much, Marissa. I will apologize from the top that my camera is not working as well as my bio is. I'm not that good with tech stuff. So my camera is not working, but I am delighted today to be here to speak to you on behalf of the Delaware Developmental Disabilities Council. The council is briefly, our job is to educate, advocate, and inform the community through legislation, projects, policy, procedures, with a real emphasis on community. We know that community is the heartbeat of what we do. So we are made up, the council is made up of primarily of individuals with disabilities, family members of those with disabilities. And then we have some community partners, meaning providers and other leaders within our network. But my role is to elevate the work that the council does and being able to do trainings like this and connect with you guys virtually or in person is the highlight of what I do. But the council really embodies the whole community analogy of reach one, teach one. So that's just us in a nutshell.
Right. And like Francisca said, I'm with the Community Legal Aid Society Incorporated. If you're not familiar with us, our acronym is CLASSY. We are a not-for-profit law firm. We've been in operation since 1946. Our mission is to combat injustice through creative and persistent civil legal advocacy on behalf of Delawareans. We have a number of different programs. You may be more familiar with our services for individuals who've experienced domestic violence, our medical legal partnerships, and our public benefits and housing programs. I am with our disabilities law program, which is the protection and advocacy system for the state of Delaware. And I'm sorry, I'm just getting my voice back from a cold, so it may come in and out a little bit. The protection and advocacy system, if you're not familiar with it, is something that exists in every state and territory of the United States. It came about as a result of widespread concerns about the treatment of people with disabilities in facilities. We do individual representation, systemic advocacy, community education like this. We serve on committees and task forces. We also do monitoring of facilities to ensure abuse and neglect is not happening, as well as we serve as an independent abuse and neglect investigator when, for example, we receive a report that someone was abused at a place like a psychiatric hospital or group home. Okay, so the goals today are to identify why inclusive and accessible victim services are needed, then to understand the basics of US disability rights laws, then to gain understanding of disability etiquette and best practices when working with people with disabilities, and where to go for more support, resources, and technical assistance. Okay, so first turning to why do we need inclusive and accessible victim services? Why are we sitting here talking about this today? First, it's important to understand that people with disabilities are a significant and sizable population in the United States. I think on your screen, you can see a visual representation of an approximation of the number of adults with disabilities in the United States. So estimated that about 1 in 4, 27% of adults have some type of disability. And I have here some breaking that down a little bit more just to understand the population. Around 12% have some type of mobility or orthopedic disability. About 13% have a cognitive disability or disability that impacts thinking, like concentration. About 7% of adults have a disability that impacts their ability to do everyday life activities for living alone or independently. About 6% have a communication disability, like who are deaf or have difficulty hearing. About 5% have a vision disability or blindness, and about 3.6% have a disability that impacts their self-care, dressing, bathing, etc. Turning to kids, the disability rate is a little bit lower, about 18% here in Delaware. And that's roughly broken into about 1% physical disabilities, 10% learning, and 7% emotional or behavioral. And the census data indicates that across the lifespan, the estimated incidence of disability is around 12%. Okay. So now that we have an understanding of about how many people with disabilities we're talking about in Delaware, what's the data in terms of how these individuals are impacted by crime? And I'm using some slides here that are from training that was developed by the Office for Victims of Crime Training and Technical Assistance Center. Is a very detailed and robust training that is available for free online. So it is linked here if you want to do further training. But just for this overview presentation, I've pulled out some slides that are relevant to today. So any slide that you see with those puzzle pieces, please, those are from that training. So everywhere that we talk about them, that is from that national crime training program. In 2010, a report came out where we learned more information about the rate of crime victimization amongst people with disabilities. And what it showed is that young and middle-aged people with disabilities experience higher rates of violence than people in their age cohorts that don't have disabilities. Just breaking that down into type of crime, you can see the majority are assaults. What the data showed is that people with disabilities experience nearly double the rate of violent crime. They experience 3 times the rate of rape and sexual assaults. And female individuals with disabilities also experienced double the rate of violence as well. People with developmental disabilities, so that might be a disability like autism or an intellectual disability, experience rates of 4 to 10 times more violent crime. More than 50% never sought assistance from legal personnel or treatment service providers. The study also revealed that more than half of the violent crimes against people with disabilities were against those with more than one type of disability, and that individuals with cognitive disabilities had rates of victimization higher than those with other kinds of disabilities. So that data was from 2010. I've pulled out just some more recent data from 2017 to 2019 that shows people with disabilities were victims of about 26% of non-fatal violent crime, while accounting for about 12% of that population. So we see that about double rate continuing. The rate of violent victimization against persons with disabilities was almost 4 times the rate for people without. 1 in 3 robbery victims had at least one disability, People with cognitive disabilities had the highest rate of violent victimization among other disability types. And 19% of rape and sexual assaults against people with disabilities were reported to the police, compared to 36% for those without disabilities. This slide talks about why women with disabilities are less likely to report, but it also applies to many male victims as well. So factors that contribute to lack of reporting by people with disabilities include lack of job or independent support. So maybe they don't have someone who can support them in understanding how to make the report, or having emotional support to make the report. So that can cause lower reporting rates. Lack of shelter, housing, and transportation can also contribute to that. Isolation. So people with disabilities sometimes are at a facility or are home alone, and maybe don't have a large support network in the community that can help them. Also, fear of questions about if it's for example, a parent with a disability, fear that their ability to parent their child will be questioned if they make a report. There are complications in reporting a crime, believability. So a lot of people may fear that they won't be believed if they come forward. They may have disability-related behaviors that are, viewed in a way that makes them seem not credible. So, as an example, maybe they have difficulty time sustaining eye contact, and if a lack of making eye contact is viewed by an officer as lying, right, that may make it more difficult for them to make a report and be believed. They may have health-related issues where they have to coordinate a direct service care professional, like a nurse or a health aide, equipment, special transportation, all to go to the police department to make a report. They may not have sufficient income to make that trip. Concerns about finances, needing help to make a report, having alternative communication means, and having that being a barrier to report as well. Some abuse and crimes that people with disabilities experience are overlooked by law enforcement professionals, and others with things like withholding medication, care services, equipment can be a form of abuse. Causing physical pain during care. So maybe a family member has to help bathe a person with a disability, and they do it in a way intentionally to cause pain that's not necessary. Doing physical restraints can be a type of abuse. So impairing someone's ability to move, whether that's with some type of mechanical restraint or physically with their body. Failing to clean or bathe somebody that they are responsible for. Controlling the person's finances without authorization, or doing it for their own self-interest. Using personal items or property without permission. These are types of abuse that people with disabilities may experience. Okay, so we've talked about the rates of disability, we've talked about the rates of crime victimization of people with disabilities, and why that might be overlooked or why it may be a barrier. I also want to touch on some of the history of discrimination against people with disabilities in our system, because all of these different factors come together to make it harder for people with disabilities to have to be believed, to be able to report when crime happens to them, and also to get the services they need to heal. So going back into the early 20th century, we had a, a legal system that devalued the lives of people with disability. There were even efforts to eradicate people with disabilities. In the early 20th century, we had eugenics, where states saw authority to involuntarily sterilize people with certain disabilities. The goal that was articulated in a famous Supreme Court case called Buck v. Bell in 1927 was that that states had to protect society from, quote, degenerates. And they didn't, this was the way that the highest court in the land looked at people with disabilities as something that needed to be eradicated. People with disabilities were often sent to institutions, or sometimes they were called schools, where they were moved from their families and communities. One famous one is the Willowbrook State School in Staten Island, where children were sent with no real hope of having anything other than that being their life there. The residents were warehoused with no hope of ever leaving. They were unknowingly used as research subjects. They were subjected to physical, emotional, and sexual abuse. This was brought to life in 1972, back when Geraldo Rivera was actually an investigative journalist. He was the one who brought this to the national attention with an expose on the Willowbrook School. And what he said about it was, I first heard of this big place with a pretty sounding name because of a call I received from a member of the Willowbrook staff. The doctor invited me to see the conditions he was talking about. So unannounced and unexpected by the school administration, we toured. The doctor had warned me it would be bad. It was horrible. There was one attendant for perhaps 50 severely and profoundly impaired children lying on the floor naked and smeared with their own feces. They were making pitiful sounds, a kind of mournful wail that's impossible for me to forget. This is what it looked like. This is what it sounded like. But how can I tell you about the way it smelled? It smelled of filth, it smelled of disease, and it smelled of death. As a result of that expose, a number of things happened to make it so that other children were not subjected to this kind of horrible treatment. 1973, we had the Rehabilitation Act enacted. Many of you, and we'll talk about it a little bit later, may have heard of the Rehabilitation Act, and in particular, Section 504, which has to do with disability discrimination. In 1975, the first protection and advocacy program was enacted, the protection and advocacy for people with developmental disabilities. In 77, the implementing regulations for the Rehabilitation Act were enacted after a mass sit-in that lasted almost a month, demanding that the regulations finally be enacted. In 75, we had the first version of the Individuals with Disabilities Education Act, called the Education of All Handicapped Children Act. And then in 1990, we had the first version of the Americans with Disability Act. So all of this came following that outrage that resulted from the world, from the nation, learning about what's happening at places like the Willowbrook School. So did we fix it? Today, individuals with disabilities can get an education, they can work, they can love, they can live. There's education that's widely available in the public about the benefits of inclusion, of universal design. There's supportive services that can help people with disabilities live in their own homes. We have technology that helps people communicate who cannot communicate through other means. We have all of this that help people with disabilities do all of their important life functions, but in a different way. So is the problem of disability solved? No, unfortunately. As we'll talk about today, there is still significant disability bias and discrimination. Our work is not yet done. Examples of myths and bias that people with disabilities experience, that they're helpless, assuming somebody needs help without someone asking, that they cannot speak for themselves, turning to a parent or caregiver instead of the person with the disability, that someone who's nonverbal cannot communicate. They may just have a different way of communicating. That all disabilities can be seen. There are lots of people who have what we call invisible disabilities, where you can't tell by looking at somebody that they have a disability, but they do, and they may need their services in a different way because of that. That people with disabilities cannot consent to sex or have intimate relationships. That's not right, that's a myth. That people with disabilities are not credible or believable. So we see that a lot, especially with people who maybe have a mental illness or a history of one, that they're dangerous, that first responders only encounter them in crisis, that people with developmental disabilities don't benefit from therapy. I've heard that a number of times. That you, not the person with the disability, know what accommodation and supports they need. That caregivers and guardians always act in the best interest of a person with a disability. And other myths include that people with disabilities can't make decisions and that they can't give informed consent. Some statistics on bias that happens today. One researcher found that disability bias had only shifted about 3% in a 14-year period studied, compared to sexuality biases, which dropped 64% for the same period. So although we're making progress on inclusion in other areas, disability inclusion and bias is fairly stagnant. Another study found that people with disabilities, including emotional, physical, cognitive, or sensory disabilities, were significantly more likely to be arrested by age 28 at around 43%, while those without had a lower probability of around 30%. Another study that held anonymous focus groups with doctors and specialty healthcare providers resulted in the healthcare providers admitting to broad disability discrimination, including refusing new patients because of their disabilities to avoid having to accommodate them, figure out how to communicate with them, or because of concerns that they'd have to give them extra time. And that was a study that was highlighted in a New York Times article that I include on the slide and will send out as a follow-up afterwards. Right. Before I move on, Emmanuel, is there anything you'd like to interject here?
No, you're good. You covered it well.
Okay. Great. So now that we have a good idea about why we're here talking about this, let's jump into an introduction to disability rights law. So this is just a very high-level introduction. There are nuances to all of these laws, so we're just trying to give you a general sense of the legal landscape that impacts services for survivors with disabilities. Okay, there are a number of laws that impact individuals with disabilities. We're mostly going to be talking about 3 of them today, just because of time constraints. So the first is the Americans with Disabilities Act, or the ADA. The second is Section 504 of the Rehabilitation Act. This applies to the federal government and anyone who gets federal money, so programs that have federal grants, for example. And then the Delaware Equal Accommodations Law, which is the state anti-discrimination law that protects people with disabilities from discrimination in government services and from businesses. Okay, so turning first to the Americans with Disability Act, there are several different titles. This is just how the law is broken down. So each title has a different subject matter that it covers. So you might hear someone reference the ADA, or you might hear someone reference Title II as an example. So this is why it has to do with which subject matter of the ADA that we're talking about. So the first title is employment. So this title protects individuals from disabilities who are working or seeking to work for being discriminated against by an employer. So we're not going to talk about that today. We're going to focus on Title II and III. Title II covers public services. So these are services from state and local government entities. It covers all public entities, covers courts, municipal government, police departments, the victim advocacy services at the Attorney General's office. It also covers schools, DFS, and more. Title III of the ADA covers public accommodations and services. Public accommodations is a legal term that basically means businesses, places that are offering goods or services into the commerce. So they could be operated as a for-profit or a nonprofit. They have to fall into certain categories, which are listed. So the lodging, so that'd be like a hotel or a motel, places serving food or drink, places of entertainment, stadiums, theaters, places of public gathering, sales and rental establishments, public transportation centers, service establishments. So that could be a therapist's office, a lawyer's office, a not-for-profit that provides services to victims, hospitals, clinics, etc. Places of public display, that's like museums, libraries, places of recreation. An example would be a zoo. Private schools, social service centers, so homeless shelters, victim services centers, daycares, places where you go to exercise, so the bowling alley or a gym. And then Title IV covers telecommunications. Title V has some miscellaneous provisions. Okay. So as I explained, Title III covers public accommodations, which are essentially businesses. It does not cover private clubs, religious organizations, public entities, because that's covered by Title II. Housing, that is longer term, that's covered by a different law, the Fair Housing Act. Air travel, which again is covered by a different law. And telecommunications, which is covered by a different section of the ADA. Okay. So what is a disability under the ADA? Disability, or a person with a disability, is a qualified individual who has a record of or is regarded as having a physical or mental impairment that substantially limits one or more of their life activities. So just to break this down a little bit, a qualified person, meaning there's someone who's eligible for your services. So if your service is to provide crime victims with therapy, but the person coming to you for services is not a crime victim, then they may not be a qualified individual. Has a disability is clear, right? They currently have a disability. What has a record of means is that there's a past documented history of disability. So maybe someone had cancer that caused them to be a person with a disability, but they know they're in remission. So they have a record of having a disability, or is regarded as having a disability. So that means they don't necessarily have a disability, but they're looked at as having one. So maybe, they have a scar that makes it look like they have a disability, but they do not, in fact, have one. So all of those individuals are included as someone who's protected by Americans with Disability Act. A physical or mental impairment that substantially limits, what that means is we look at the nature and severity, the duration and length of impact. The ADA is meant to be looked at expansively, so it's a very wide and generous interpretation of what substantial limitation means. Life activities can be things like walking, speaking, hearing, seeing, working, caring for yourself, learning, thinking, concentrating, right? Interacting with other people is a major life activity. Reproduction, operation of a major bodily function, that's one of my favorites because it has many applications. It can include the operation of the brain, right? If somebody has a mental illness where they have an imbalance of that's an operation of their brain that's protected by the ADA. Okay, so now that we know what a qualified individual with a disability is, what does the ADA protect them from? So entities are prohibited from discriminating against people with disabilities, right? You can't treat people with disabilities differently because of their disability in a way that discriminates. Entities are required to ensure that qualified individuals with disabilities have an equal opportunity to participate in and benefit from their programs, services, and activities. Okay, so services have to be accessible to people with disabilities. The ADA does not allow you to refuse to allow a person with a disability services or to participate in services. The ADA provides that programs and services must be in an integrated setting, that you may need to make changes in policies, practices, or procedures, that you may need to provide auxiliary aids and services for communication, and we'll get into more detail about all of this, and ensure that programs and services are accessible, including the removal of physical barriers if needed and readily achievable. Okay, so we're going to talk about some common issues. I'm going to give some examples, and then Emmanuel will jump in with some more concrete examples just to help you understand how this can happen in the real world. So physical access is a major problem. So what we mean by physical access is, someone literally can't get in the building or in the room. There's inadequate or non-existent accessible parking. That's a big one. That the parking's not on an accessible route. So maybe there's accessible parking, but you can't get from the parking to the door because there are steps in the way. There's a missing access aisle, so you can park, but you can't get out of the van. Um, Lack of curb ramps, new constructions that don't comply with the new, well, not new now, but with the ADA accessibility guidelines for construction. And the ADA requires that businesses and government entities remove architectural barriers when readily achievable. And then when there are alterations in new construction, that they comply with the ADA AG. Emmanuel, I'm gonna.
Yeah, and I would just add when we look at the potential barriers, especially with all of these are important, but when it comes to receiving services, if someone can't get in the building, that automatically eliminates them from being able to utilize your services. It wasn't until the pandemic came that things began to be more virtual, but some services, such as treatment for being a victim, could very well be much delivered better in person. People may feel comfortable, more open to doing things in person. So being able to remove those barriers and ensuring that people can get in and out of your establishment not only allows you to deliver the service, but to truly embody every part of that person. So being able to look at someone as a whole person and not based on what service they need speaks from the moment that person pulls up to your establishment or you know uh being able to communicate. Marissa talked earlier about people who may use different means of communication. So being able to eliminate as many quote unquote barriers as possible, again, not only allows you to deliver the service that you signed up to deliver, but it allows that person to really be seen as a full person and not just based on their diagnosis. Because again, some disabilities may not be visible. So thinking about the parking lot, a lot of times when people park in the handicap spots, we may look for do they use a wheelchair? I don't see a wheelchair in their car. I don't see the need why they, may need to park there. Uh some may uh some may some may walk and may not be able to walk as far, or may have breathing difficulty. So just being able to eliminate those barriers speaks value to the service that you're delivering. So um I would look at the building as structured wise. Is this truly a good place to open up or to deliver service? Or if you're already in the establishment, can I go around my building and do a checklist? There are checklists delivered by the Mid Atlantic ADA Center where you can literally print out a checklist online. I'll make sure you have that resource as well. But there's a checklist that you can print out that you can go through your building and do an assessment. And if you need help with that assessment, I'm sure you can call either Marissa or myself to help go through what some of those things could look like for your establishment.
Yeah, and some access issues can be accomplished more easily than others. But there are things like ramps that you can add on. You can, if you have one step into a building, that can be turned into a sloping ramp instead, for example. These are things that may be not as big of a barriers. It can even be things like, if you have a client coming in with a wheelchair, moving other chairs from the room so that they have a place to be able to come in and have the door closed. So it's not all necessarily significant construction. They may be minor or easy changes to make as well.
And Marissa, if I can add real quick, one of the other things, thinking about, I know we're talking about structure and the way, ramps and the way buildings look. But one of the things that people can really start doing when they receive a phone call from an individual requiring about their services, maybe they're looking for a new provider. So they would be considered a new patient. Part of that new patient conversation, asking about what services you deliver. Do you speaking about victims' rights? Do you have new are your therapists taking new patients? Part of that conversation can also be, yes, we're located at XYZ. We do or we do not have an entryway if you need an accessible entrance. I know a lot of times we put things on the patient to ask those questions, but there is some ownership from the provider as well about being transparent about what's available and what's not. Because if somebody like myself were to take paratransit and then get all the way to the building, get dropped off, and then you realize you can't get in, and it's like, what do I do? Now I got to either sit there for an hour and a half, waiting for a bus to come back. The weather may be difficult, so many different things, but those are potential barriers could be eliminated even through conversation.
Thanks, Emmanuel. Um, so turning back to physical accessibility, just focusing on courtrooms. So for victims that have reported or that the crime has been reported, and they're going to be going into court, courtrooms need to be accessible for them. They may need reasonable accommodation or assistive technology in order to participate in the proceedings. So that might be a device so that they can read captioning about what's being testified to during the proceedings. It may be that they need extra time in order to respond. Maybe they have physical accessibility needs that need to be addressed in the courtroom. So I'm going to show you some images in the next slide of things that can be done to make physical space more accessible. These are courtroom pictures, but you can think about in other types of government offices and buildings how these types of changes could be made as well. So the top left, it's an image of a courtroom. You have the public seating separated by a low wall. They're opening for the wall. There used to be a gate that would open and close as someone came in and out. The gate was removed so that if someone with a wheelchair, whether it's a litigant, a victim, a accused, or counsel, can get in and out of the space at counsel tables without having to have somebody else open the door for them. In the upper right, we see the public seating, that one of the benches in the front is not as wide as others, making a space for a wheelchair. In the bottom left, we see a ramp to get into the witness stand. And in the bottom right, we see the courtroom with computers, monitors at the top left and right of the room with captioning, so that someone who has a hearing disability who can't participate by hearing what's being said can see and read the captioning. Okay, so we talked about physical accessibility. Now we're going to talk about program accessibility. So program accessibility issues that we frequently see are exclusion from programs, including discriminatory eligibility criteria. So an example could be you can only participate in this social service, like maybe it's a homeless shelter, or maybe it's some other type of program, but it has a work requirement as a requirement. Well, that may have the effect of excluding people with disabilities whose disability impedes their ability to work. It could also be refusing services to victims with certain diagnoses. I don't provide therapy to individuals with developmental disabilities, could be discriminatory under the ADA. Blatant discrimination, refusing to offer services because the person seems too disabled. Segregated services, so having completely different services for people with disabilities than for the general public. Common issues with program access can include unequal or different services. You cannot force someone with a disability to use separate programs unless necessary to ensure equal and effective service. Forcing a person with a disability to accept a special accommodation or benefit. So, maybe we have a victim with a disability who has a difficult time speaking. They can speak, but they need more time, or, maybe they need some prompts, or they need technology. Well, forcing them to have their parents speak for them instead is not, that can be discrimination under the ADA. Requiring a medical letter when not required for others can be discriminatory. Failing to make what's called a reasonable accommodation or modification to policy or practice when necessary to afford equal access can be discrimination, and we'll talk more about that in a moment. Communication. Entities have to provide effective communication. If your victim is deaf, writing post-it notes back and forth is not an effective means of providing services. What is effective and what's required is going to depend on the specific circumstance. So asking the person with the disability, what is the most effective means to communicate with you, is entirely appropriate. Someone may need large print. If you're asking them to sign forms, they have to be able to read what they're signing, right? They need it in a larger size. Or, for example, if someone's blind, sending the paperwork electronically in a format that their screen reader can read prior to their signature can help ensure effective communication. Emmanuel, I'm going to pause again in case you wanted to add anything before I move on.
Under the communication piece, some providers are now starting to, like when you get closer to your appointment, they send you either a text message or I've seen it through email to complete forms. And now, because of the pandemic, again, things are becoming more accessible, but there are also some providers who rely on the person to fill out that form through text message. And even though it's electronic, the text message version may not work for an individual with the disability. So again, just being mindful of what those communications look like now because I've been in the game for a while. I don't have a problem, calling the provider and saying, "Hey, I appreciate the electronic version through text message, but can you send it to me in a PDF or electronic format for me to complete those documents?" Because to me, at the top of everything we talked about today so far, communication has to be at the top. If we can't communicate, then we can't get anything else done from the legal aspect to service delivery. So really looking at those barriers for the communication is crucial to deliver effective services.
Thanks, Emmanuel. Drilling a little bit more into reasonable accommodations or modifications. To make it confusing, some of the ADA talks about reasonable accommodations and some talks about reasonable modifications, meaning the same thing. And under the Fair Housing Act, we use reasonable accommodations to mean changes in policies and practices, but reasonable modifications to mean physical changes to housing. So I'm just using both terms here so that we don't have to define which title the ADA and to make it a little bit easier. But when I say reasonable accommodations or modifications, what I mean is a change in a policy, practice, or procedure so that a person with a disability can enjoy the same benefits, privileges, and services as a person without disabilities. I like this image in the lower right, which is a stone with a piece of wood, and then balancing on one side of the stone is one large stone, and then on the right is a stack of stones. And the bottom stone is adjusted in such a way so that everything is level. And what the ADA does, kind of like the stones here, is sometimes you have to do something differently to treat people the same. So what I mean is that you may have to make exceptions or change policies so that people with disabilities can get the same service. So an example of that could be that you have a no pet policy for your business, but you allow in a service animal as a reasonable accommodation to a person with a disability who needs that animal for disability related reasons. So you are treating the person with the disability differently by letting this service animal in order to treat them the same by providing them the service. Some other examples of reasonable accommodations, maybe the person is medically fragile and tries to avoid outside contact for that reason. So they may request remote services as a reasonable accommodation. Some individuals with disabilities have alternate decision makers that they've put into place, like a power of attorney or an agent under an advanced health care directive or a supporter under a supported decision-making agreement. And they may need a supporter there to help them understand and process and make decisions. So allowing in a support person when you might not otherwise is another example of reasonable accommodation. Scheduling. If you're in a service that provides appointments, a reasonable accommodation may be scheduling that person for a longer appointment because of their communication needs, or scheduling them at the end of the day when there are fewer people in the office if needed for their disability. Those are some examples of accommodations. Emmanuel, did you want to add anything before I move on? Okay. I will
Sorry,
note
Miss.
that. Oh, sorry, go ahead.
So no, I was talking and I didn't realize I was still on mute. Um, the only thing I would add 2 points. The example about service to animals. That is a good example. I would throw out the fact that now if the service dog is disrupting service or not behaving in the manner that a service dog should be performing, meaning barking or lunging or again disrupting services, then there are things that you can do to have, to tell the person, hey, your dog is interrupting service and things of that nature. Because again, that service animal is not there to disrupt services, there to help the individual, do what he or she needs to do to live that daily life. And then the other point about scheduling or making the appointments longer. The thing I would add to that, when it comes to scheduling, and again, this was related back to communication. Someone may need to transfer. They may need to transfer out of their mobility equipment to your couch or your exam bed or whatever they may need. So leaving that transitional time for people to be able to do that again allows you to serve them in the full capacity in which the services you provided. And part of that time scheduling can also be used to ensure that people with disabilities and their families fully understand the information that you're providing them. Maybe you have a checklist to go over, or maybe you have to explain to them what your services are going to look like for the next 6 months to a year. That would give you that time to have that conversation, um, so people can fully understand it, and it's not rushed because you then need to move on to the next patient that you're seeing.
Always hard to find the unmute button when you need it. Thank you, Emmanuel. And then lastly, with reasonable accommodations, I just want to highlight the word reasonable, right? They have to be reasonable requests, not unreasonable ones. And when someone makes a reasonable accommodation or modification request, you can enter into what's called an interactive dialogue, where you have a back and forth discussion about what the need is and what an appropriate accommodation or modification would be to meet that need. So sometimes what the accommodation modification ends up being is not necessarily what the person initially asked, because there's a back and forth dialogue between the service provider and the individual to identify an accommodation or modification that is workable in the context. And what's not workable are undue burdens and fundamental alterations of the program. So a fundamental alteration is something that would change the nature of the service completely. So if you're having a beach volleyball tournament, um, it would be a fundamental alteration to have that event indoors. So just as an example, an undue burden could be administrative or financial burden, but it's going to be looking at, like, for example, your budget overall as a business, not just at the service that you're providing for that specific individual. Okay. Turning in more detail to communication. Um, Communication needs, which we also commonly referred to when we're talking about auxiliary aids and services. So these are services or devices that are needed to facilitate communication. So you can see today we have one on our Zoom. We have an American Sign Language interpreter. So interpreters may be necessary to facilitate communication with someone whose primary language is American Sign Language. Healthcare providers, police, lawyers frequently fail this. They do not provide interpreters, and they do not ensure effective communication via interpreters when it's necessary. And they can be liable under the Americans with Disability Act for this failure. If a person with a disability requests an advance for an interpreter, an interpreter can be used when it's the effective means of communication. Alternatives aren't effective. So I think earlier I used the sticky note example. Not everyone who signs in American Sign Language are fluent in written English, which is not something everybody knows. They are two different languages. So communicating and writing is not necessarily going to be an effective alternative for somebody. And that's really critical when the content of the communication is really important. So, when it's giving a police report where the details really, really matter, getting services for trauma, speaking with a lawyer about your legal options, all of this, the details are critical. And so you need an effective means of communication. For some individuals, remote interpretation is appropriate and effective, and for some it is not. There are regulations that go into screen size that's needed and internet stability, for example. But you may have someone, for example, who has both a visual impairment and who uses American Sign Language and who needs an interpreter physically in person in order to have effective communication. And there's a typo here. The person with a disability does not necessarily have the right to choose the specific interpreter, but if they indicate that interpretation is necessary, legally speaking, more likely than not, it's going to go in their favor that an interpreter was necessary. Other forms of communication alternatives could be large fonts, electronic format for letters and forms, electronic signature, allowing a designee to do the signature. So maybe someone cannot physically sign, can't electronically sign, but they can delegate their signature to somebody else to sign on their behalf. Using captioning and transcription is another. So we saw those captioning devices in the courtroom example. There are numerous assistive technology devices that can help people with disabilities in a variety of means. There are things called FM systems where there's a microphone close to the speaker and the person has a headset where they can hear the sound focused on the speaker, and it helps to filter out some of the background noise, for example. Using support people and alternative decision makers when a person with a disability wants that. Having modified interview techniques. We're not going to go today into all of the details, but I have included at the end of the PowerPoint some resources, including some trainings for individuals who are doing victim interviewing on how to interview, for example, an individual with an intellectual disability. in a way that allows them to share their story accurately. And to getting the information from them may just be you have to ask questions in a different way. And more time, which we talked about. Turning to the courtroom, just some examples of devices that can help with communication. Video phones are pictured in the upper left. In the upper right, you see a variety of assistive listening devices, and then translation equipment in the bottom. A lot of individuals who use American Sign Language, for example, have phones that are have relay numbers where you're connected via an interpreter who has video connection with the person who's deaf to interpret, and then audio connection with you, so that you can have a phone call with the individual like you would others. Too far. Okay. Another common issue that we wanted to highlight are service animals. Under the Americans with Disability Act, there are only two kinds of animals that are authorized: dogs and miniature horses. So you'll see on the slide in the upper left, there is a miniature horse assistance animal. And then in the bottom, you see a service dog who's assisting someone with a white cane, indicating they're blind. So service animals, again, one of the common misconceptions is that it can be any animal. For the ADA, which applies to businesses and government programs, it's only dogs and miniature horses. The animal also has to be trained to perform a task related to a person's disability. So it's not just an emotional support animal, they have to do a specific task. There is no requirement that they have a certification. There's no requirement they wear a vest or have a special badge or tiny sneakers for your miniature horse. None of that's required. People can train their assistance animals themselves. So they don't need to show you a certificate. They don't have to have paid tens of thousands of dollars for special training. But the animal does have to do a task. So it may be that they alert to, for example, an impending seizure. Maybe they alert when someone's blood levels, insulin levels, not where it should be. It could be a dog that's trained to alert when it's time to take medicine. It could be a seeing eye dog that's trained to help someone navigate safely. It could be a psychiatric service dog that's trained to perform a task for someone's mental health disability, whether that's recognizing when a panic attack is about to happen to help somebody to step out of the situation. Maybe they're trained to remind of medications or alert to a need for, as needed medications. As long as it's trained to do a task that's needed for persons with a disability, it can be considered a service animal under the ADA. Now, there are some exceptions. As Emmanuel had noted earlier, service animals cannot attack people or other animals and still be allowed admission. They can't go to the bathroom all over the place. They have to be in control of the individual with disability. And they can't pose safety or health hazards by being out of control. Someone else having a dog allergy is not a reason to exclude a service animal. what the US Department of Justice says in guidance is that you have to do your best to accommodate both individuals. So that might be moving. If two people are in a waiting room, one is allergic and one has a service dog, moving them as far apart as you can, or otherwise identifying ways to address both interests. You can't take a service animal into an operating room because that would be a health hazard and a safety hazard. The individual with a disability can't task you with cleaning up after their dog. And like I said, they have to be under control. As a service provider, you are only allowed to ask 2 questions. Is this a service animal that you need for a disability? And what tasks does it perform? You don't get to ask other questions. Okay? You don't get to ask for a certification or documentation like that.
And I would just add to that portion after asking those 2 questions, the person does not have to perform what I call the magic trick. Because typically after people ask that question, they want you to perform the magic. It is not magic, it is a service that that dog is fully trained to perform. And I say that because I have a service dog, and I know, um, believe it or not, dogs ask more than children for you to perform. So as a provider, once you ask those 2 questions, that's about as far as you can take it. After the person answers your 2 questions, that is it. That is all. They're not required to then demonstrate to you the dog opening the door, pick up the wallet, so on and so forth. Now, if you stick around long enough, I'm most likely to drop my cell phone or drop my wallet, so you will naturally see my dog do those things because I need it to be done, but you're not allowed to ask us to perform those to confirm that this is indeed a service animal.
Thanks, Emmanuel. Just again highlighting, Emmanuel had talked earlier about how someone may need accessible parking, but they don't have a wheelchair because they have a non-visible disability. So too with service animals, the animal may be helping with an unobservable disability that you can't see, and that's not a reason to exclude the animal. Some other psychiatric service animal examples could be helping to prevent wandering. If somebody has a tendency to wander, that can help to keep them safely in the place they're supposed to be. They do have to comply with general health and safety restrictions like being a dog license, having vaccinations, things like that. So they still do have to do those things. And then when I spoke earlier about the dog being under control of the owner, it does not have to be leashed if the leash would interfere with its job. Okay. And then last point that I wanted to make about service animals is that there are no breed restrictions. So there's nothing like saying that a pit bull, for example, can't be a service animal. Okay. Moving from the ADA to Section 504 of the Rehabilitation Act. So the language under the Rehabilitation Act is very similar to the ADA, and it's implemented in a similar way. But what the Section 504 says is that no otherwise qualified individual with a disability in the United States shall solely by reason of his disability be excluded from participation and be denied the benefits of or be subjected to discrimination under any program or activity receiving federal financial assistance or under any program or activity conducted by any executive agency or the U.S. Postal Service. There are different sets of regulations for different agencies. So, healthcare versus transportation, for example. But in practical terms, it has a similar application to the ADA. This is going to most likely in the victim service world come into play with healthcare providers that accept Medicaid and Medicare, state and local agencies that receive federal grants. So are you a victim service program supported by VOCA funds, for example? Then you would have to comply with Section 504. So any federal money that's coming in would trigger Section 504 to apply to your organization. Okay. Now turning to state law, the Delaware Equal Accommodations Law. This is a state anti-discrimination statute that covers many protected classes plus disability. It covers access to public accommodations and government services similar to the ADA. It does not cover employment. There is a separate state law that covers employment. It has its own definition of public accommodation, which is any establishment offering goods and services, state agencies, local agencies, and state agencies performing public functions. But for whatever reason, it's been interpreted not to include prisons. It also does not include housing unless it's temporary. So it can cover motels if it's a temporary stay, for example. Differences with the Delaware Equal Accommodations Law from the ADA. It has some specific provisions around service animals, including service animals in training. And one provision that is really important but very poorly implemented in Delaware is accessible electronic doors. All buildings which are constructed after 2011 have to be equipped with either an automatic door or a calling device at the entrance. That's the main entrance. So you either have to have a bell that then a staff member comes and opens the door, or you have to have an automatic door if your building was constructed after 2011. We see wide non-compliance with that, which would put any business or government office would make them vulnerable to Delaware Equal Accommodations Law complaint. Before we go into disability etiquette manual, is there anything you want to add?
No, I'm good. I'm good. You covered it well.
Okay. And I am going to turn the floor over to you. You just let me know when you want me to advance the slides.
All righty. All right, so disability etiquette and best practice. This is gonna give a quick overview of some of the things that you can do to ensure that we are using the best possible approach when interacting with people with disabilities. Next slide, please. Language. Language goes back to communication. So language is a big one on what words to use, what words not to use, and then there are some words that may depending on the person. Some people prefer different words to be used than others. Next slide, please.
Yeah, if we can just unpack that a little bit. So like the person first versus disability first, maybe, because I think some people that are in the audience may not be familiar with um, with the views there.
Understood. I thought that was on the next slide, but I can cover that. So people first language, some people may prefer to for you to say I got a disability instead of I'm a person with a disability. So there are two common things that we refer to a lot, which Arissa just alluded to, the people first language versus the disability first, and I'll kind of take a deeper dive as we go through this. Did I cover that, or you wanted to add something else to that?
All right, there's the scan mute. Yeah, I mean the default generally is to use people first language unless someone prefers otherwise. So, for example, people, some communities of people who are deaf prefer deaf like with a capital D instead of individuals who are deaf. They want to be a deaf, referred to as a deaf person. So that's a preference for some individuals. If you're not sure, what we usually use in my office as the default is people first language, unless we know that somebody wants to use the disability first language.
Marissa is gonna keep me out of legal trouble, which is good, which makes this duo even better, because I can stay out of legal trouble. But when interacting with service animals, I always tell people it's good etiquette to interact with the person because technically the animal, even though they're cute, most of I don't think I ever seen an ugly service dog. Most service dogs are really really cute. So it's kind of hard for people to interact with the person first because they're in love with the aspect of seeing a dog. But when interacting with a person who has a service dog, I always say address the person first. Especially if the dog has been through formal training. Now again, somebody could train their own dog, but if they have been through official training through a school or provider, that dog may be should be trained to ignore you. If you're not the person that handle it, they are trained to ignore you. So if you ever come up to a service dog and the service dog doesn't acknowledge you, one, that is because that's the way they're trained. Two, it's not a good idea to walk up to a dog. You don't know what the dog may do or how it may react. This is not my service dog. It looks like my service dog almost, but it is not my dog. But they do resemble each other. But again, when interacting with that person, interact with the person instead of the dog. I work in an office with three other people, and I think we as a duo are the most distracting when I come into the office because everybody wants to be with the dogs, but especially especially speaking about people who may be victims of abuse or some other thing that may have happened. That service dog could really be what that person needs. So being able to not distract the dog or pull them away it's crucial because at the end of the day they are dogs, but they have been trained, to do a job. So So the more that we can do to not interfere with that training, the better.
Yeah. And just to add, it can also be a safety issue. If you distract the dog and they miss um, identifying a dangerous situation, so maybe they miss, identifying a seizure that may happen or escalating glucose level or whatnot, it can really be a safety issue for the person with the disability. So bear that in mind as well.
Speaking about safety, especially in my case, especially getting on and off the elevator. One of the most dangerous spots to navigate with your service dog is the elevator, believe it or not. Because if you and the dog don't work together, the dog can get severely hurt by getting their back legs crushed or their hip bone crushed because the dog was not listening to your commands on when to enter the elevator. For example, my dog, in order for my dog to go on the elevator, my job is to position my wheelchair so the door doesn't close on the dog because my wheelchair can take the blow from the door versus my dog. So if someone were whistling or hey little buddy or using that low intense voice that could get either the dog hurt or get the individual hurt. So it's definitely safety is a big one, not only for the dog, but for the person, but also for you as well. Next slide, please. Uh Equipment. Meaning someone's maybe it's their wheelchair, their walker, whatever they need to move around. Maybe they need again, maybe they use a wheelchair, walker, cane, so many other different ones. But even interacting with that equipment or leaning on someone's chair. Now, some people with disabilities, such as myself, I don't mind people that I know, and know is a serious term. I should probably specify and say know and trust for someone to lean on my chair. If I do not know you, or I do know you, but we are not that close, then I don't want you leaning on my chair. You will hear people with disabilities all the time say, I am not a coat rack, I am not a leaning post. Now I do joke with my wife and my cousin that my armrest is my armrest. Cause sometimes if I'm sitting close to him, you'll naturally see him lean over and put that arm on my armrest, but it's not out of disrespect. It is out of trust and love for one another. But for people with disabilities, most of us don't like people to lean on our equipment because that equipment is an extension of the person. And you will hear people with disabilities say that. That could also be a safety issue. If you lean on someone's wheelchair, you hit their joystick, maybe they use a motorized chair. You hit their joystick and then the wheelchair takes off, or they run over your foot, or run into a table that may be in your office or wherever. So interacting with that equipment can be pretty dangerous if you don't do it properly. And then offering the help. Some people have what you will hear in the disability community say a saver's complex. Some people want to jump in right away and help you because you are taking too long. Or I even heard people say, you look like you're struggling. So So people will offer to jump in. The only thing I am struggling to do is pay my bills. Other than that, I think I'm all right. But I think we all are struggling with that in today's society. But offering to come, ask the person, if you want a couple, some people don't mind you asking to say, hey, would you like um would you like me to come? But then there are some people that say, well, if I don't ask, then I don't need your help. So I always tell people it really depends on, do you know the person? Do you not know the person? Um, now if you see somebody about to fall and you can literally see it, then I wouldn't say stand back and wait. Now if they get offended because you jumped in, then I would deal with that at that time. But if you see something about to happen, it goes back to that see something, say something. Now in my office, my coworkers know if I need help, I've been around them long enough that I don't mind asking. But when I first started, it was one of those things that I kind of treaded a little lightly, but now I don't mind asking. And that was primarily because I knew them before I started. But when you work with people and interact with them in different spaces, may require different things. So I would just, take that one as light as possible. But don't get offended if you ask somebody, do they need help, and they say, no, I don't need your help, or no, I got it. Because when I want to feel like I accomplished something, I would tell people in a minute, I got it. Even though it takes me 20 minutes longer, I got it. Because I want that sense of independence and to know that I can do it on my own. Um, Communication. Marissa touched a little bit about this earlier about people people using devices and looking at the person and using the preferred language, people first language versus identity first language. And as Marissa said earlier, go with the requirement, the default, until you know otherwise. But not using words like handicap or the R word. Um, you hear some people say, "Oh, you're spazzing out." We don't use those terms anymore. So we have this philosophy in our office. When you know better, you do better. So being able to draw attention to words that we don't use anymore will hopefully help you in your day-to-day practice delivery or being just present. I know that communication is a difficult one. I know that there are some words that we have heard, that may play a part in someone's cultural background or the way they were raised or the way they were taught. But I would always find out what the latest changes are, because the world of communication, especially for people with disabilities, but especially for everybody, the words that people use are changing. The words that people put in literature and songwriting and policies and procedures are changing, and it's changing because of doing trainings like this. So I would just, go with the default, but always make sure you address the person first and not use those words that we don't use anymore unless, if somebody tells you, I don't mind you using disability first or something like that, then you can go with that. But I would definitely go with the default. first. Marissa, was there anything you wanted to throw in there?
Um, other, don't assume that the person can't communicate. Asking what their preferred communication needs are, before getting to that view of they can't communicate. Other things to keep in mind when working with people with disabilities is really maybe having conversations about what do you need, do you need anything different from us? Maybe part of your standard intake form will include, could include questions like, do you have any accessibility needs? Do you have a disability that requires services in a different way? Can you explain to us what you need? And having that just be part of your practice of making sure that you're holistic and hearing from individuals with disabilities about how to make their services inclusive.
And I'll try to. I think we got a couple more slides. I know we're coming near the end, so we want to make sure we leave time for Q&A. So I'll turn it back over to you, Marissa.
So the next few slides are just about universal design. So universal design is a concept about making products and environments accessible to everybody, rather than having to think about changes specific for a person with a disability, making services and programs so that they're accessible for everybody. And so some examples just are like products that have easy grip handles. That is helpful for everybody, right? That's a universal design change that really helps people with disabilities to be able to use those products, but really it helps everybody. And likewise, universal access is, making a service accessible to everybody. Things like curb cuts help everybody. They help people pushing baby strollers, they help bicyclists, skateboarders, as well as people with disabilities. Closed captioning helps everybody, right, when you're in a noisy environment. So just keep those in mind when you're designing services and programs, and making changes to your physical environment. That changes that are accessible help everybody and make the service and the environment better for everybody. Just real quick before we do questions, we'll send a copy of the slides. They include a whole bunch of resources where you can go for more assistance, more information. In particular, ada.gov has plain language guidance for business owners and for municipalities and state governments that are really helpful. And the Mid-Atlantic ADA Center offers training and technical assistance as well as resources. Those are really great. And then there's some specific crime victim ones in that list as well.
Thank you both so much. That was an incredibly comprehensive webinar that I don't think I've ever had a workshop like that that really goes into all of the different topics that you all covered. So just thank you both for your time and for your energy in putting this together. So now we have about 12 minutes to do some Q&A. We do have a question already in the Q&A. So, and we have two now. So I think so I'll read the first one. So failure to make an accommodation slash modifications when necessary. Could this cover victim services slash police that led to more trauma on our survivor?
So I think there's two ways to interpret the question. So trauma can be a disability, right? We know post-traumatic stress disorder is a condition that can meet the requirements of a disability. So failure to accommodate that could be disability discrimination. So maybe, you know, a survivor needed a support person with them when they were interviewed, or they needed more time. And if that was refused, then potentially that could be discriminatory. Every case and situation is going to have an individual, set of facts and circumstances. So generally speaking, potentially, yes, a failure to provide accommodation modifications for someone who has a trauma related disability could be discriminatory. Also, okay, Rachel's providing
I
some.
was gonna say they added more to their question saying that you did answer it during the workshop. So I saw that after you started answering the question.
Okay.
Yeah.
So, and for the follow-up, that it was about communication, interviewing a person with a disability in a way that can lead to more trauma. So if a person with a disability needs to be interviewed in a different way, and that's not done, that can be discriminatory. And if that causes trauma, that may be money damages, right? So people can sue under the ADA and 504 for damages in some circumstances. So there are legal consequences to discrimination.
Okay, and we got another question in the chat. So there are some acronyms, and I'll try to make sure that I get the acronyms correct. So, is certification from a driving school required by the Division of Motor Vehicles for people with disabilities in addition to driving course and eye chart and written tests against Section 504? It's not required for the non-disabled.
Um, so this question, I think, is not quite on topic for victims, but any time there's a policy, you're going to have to look at the specific circumstances. So here, what the person is asking is, can you require certification from a driving school in addition to an eye chart and written test? And, in that situation, I would want to know more information about the situation to be able to answer that. Is it a policy that DMV is doing for all people with disabilities? Is it specific to this person, et cetera? So I don't think I can answer that, Denise, but you can email me outside of this webinar and we can chat.
Thanks for answering that, Marissa. So what other questions do you all have? Feel free to pop your questions in the chat, or you can use the question and answer function at the bottom of the screen. And then, yeah, of course, we want to keep the questions to the topic, which is supporting survivors with disabilities, victim services, that kind of thing. I think I can ask a question that maybe people might not be comfortable asking themselves. I think a lot of people, whether it be supporting survivors with disabilities or supporting survivors of like pretty much any, like, like I did a training on Latino survivors. I think people are afraid to make mistakes, so they don't try sometimes. So what advice do you have for people who really do want to implement all of this into their practice, but are nervous to make a mistake?
Yeah, well, one thing I will point out is not trying can have legal repercussions, right? If you don't try, and the impact of that is discriminating against someone with a disability, you may find yourself in hot water there. So take the leap to be uncomfortable, right? Sometimes discomfort is necessary for learning, and that's okay. And most people, you know, if you start a dialogue with them to try to understand, um, will be receptive to that. But just making assumptions or not trying at all is gonna be a problem. And then let me see, let me stop sharing this, and I'm gonna share um, some websites that can be useful. So another thing that I would suggest is learn more, um, and use some of the resources that we have in the slide, and then I'm going to put onto the screen in a moment to learn more about what you need to do specific for the service or program that you're running. And then while I'm figuring out this new screen share, I see Emmanuel wants to say something.
Yeah, and I would just add, you know, especially if you are a service provider, remember that when people are coming to you, they are at one of their most vulnerable states. And I think sometimes focusing on not wanting to make a mistake is the mistake, because the reality is you're human. You are most likely going to make some mistakes, but not wanting to try is the biggest mistake that you can make. And being able to utilize, especially in the state of Delaware, being able to utilize that we're small. Reach out to your neighbors, reach out to leaders in the field, to ask those questions. Even if you have a question that comes up and you're not sure how to interact with this person or how to solve whatever they need, then don't be afraid to say, listen, I don't know right now. Let me reach out to XYZ to ensure that we are doing this properly. But standing back and saying, "Oh my God, I'm frozen in time and I don't want to do anything," is the biggest mistake that you can make.
Yeah. So we have one more question. I'm just getting clarification about one of the acronyms used in it. So while waiting for that, I am
They
hopefully sharing.
clarified that they were saying wheelchair with
Okay.
WC.
Um, so in this situation, a wheelchair user needs transport to a shelter, but there's no accessible transportation available. So if the police are the ones who would normally provide the transportation service, then they would have to look at what are as a means to get um, transportation for that individual. I know that location sensitivity, right, is important. So that would be, that, for example, a domestic violence shelter may not give out its address because of safety concerns and not wanting abusers to be able to find individuals who fled. But you do have to have a means for someone who uses a wheelchair to get there. And if there's a public service where individuals are transported, but there's no way to transport a wheelchair user, that is a potential ADA violation. Um, so I think that's what Denise is trying to get at.
Yeah, I think so. Um, did you want to share about this website?
Yeah, so I have a few websites open here. So this is the Mid-Atlantic ADA Center. So they are specific to our region. They do technical assistance, guidance, and trainings for businesses and government organizations. So they have a number of resources available on their website. You can also go to trainings and request training. So, for example, they did a training at the Life Conference in Delaware just this past year. So if you are with a business or a government office and you think you need some individualized technical assistance or training, this is a possible resource for you. And then the other websites I have open here are on ada.gov, which I mentioned, and I just wanted to note there's, for example, there's a whole page on common problems with municipalities in the ADA. There's a whole guidance on small businesses. There's a whole guidance on state and local governments. And then, turning to physical accessibility, we've got the ADA standards for accessible design. And how to make sure that renovations and new constructions are compliant with those requirements.
Thank you for sharing those resources, Marissa. I'll be sure to include them in a follow-up email if you send them to me. We are at time. We're at 1 p.m. I did wanted to see if you both, especially Emmanuel, since you were just sharing those resources, wanted to leave the remaining participants with any final words or any other pieces of wisdom before we log off for today.
I would just say really, really quick, thank you for giving us the opportunity to share all of this information. But feel free, take this as an open invite. Whoever's listening to the sound of my voice or communicating through the interpreter, feel free to reach out to us. We are here to serve, and knowing that people are afraid to make choices, that's what we're here for, to help with some of that. So make this an open invitation. When you get our presentation, our numbers and emails are listed. So take advantage of the people you know in your circle. And keep up the good work. Keep up the good work, and change can only be better from here.
Yeah, and I think also as you're learning and if you have questions, ask people with disabilities. And we all know the phrase, right? Nothing about us without us. Ask us. So, like Emmanuel said, ask, and if we don't have the information, if the service recipient, if it's not an individual service recipient, it's more global issue, ask. If you have a question that's specific to a patient or a victim that you're working with, and you want to know, what accommodations they need, if any, ask them.
Yeah, thank you both for sharing those parting words. And I'm going to put in the chat really quickly a link to, I'm going to also send this via email, but if you want it now to receive your participation certificate with the hours completed. And then also there's a link to complete a survey to provide feedback on this webinar. So please visit those links. I'll also be sending them via email as well. But thank you all so much for joining us today. Thank you to both of the presenters, and thank you to Betsy as well for providing interpretation today in American Sign Language. And I hope you all will join us for more DVCC webinars. So have a great rest of your afternoon. Thank you all so much.